Artificial Intelligence, Law and Justice, Section 16, 3 of 4, Generative AI and Copyright Law. We will do a recap of that. In the earlier session, we did issues in the machine learning copyright, including issues in text and data mining. We also issued various policy options, including MLSA, general purpose technology. Then, in this session, we will look at some of the things which are very interesting. First of all, we should also understand something, that technology is not something authors have not been using. In fact, authors have been using technology since time immemorial. For example, the spelling and the grammar and thesaurus features in Microsoft Word, which we use traditionally, which we use on a day-to-day basis. And then this is a traditional digital tool for authors. And then there are lots and lots of educational chatbots for learning and knowledge acquisition. But the generative AI models, they became a game changer. They resulted in a transformation because they are so versatile than what we have been using as digital tools by creators. So ChatGPT and NLP models of the tools, they created a totally new framework to do work to create for creators as well as for others, because they create high quality works with a single prompt. And more importantly, they have the unprecedented capacity not only to create works but also to extract, contextualize works, and then they improve based upon the user's frameworks. In the sense that if you know how to do good prompts or how to handle prompt engineering, there are immense, endless opportunities for you as a creator to keep on creating works. Also to create on adding text to, in the sense that adding its creative capacity. So generative AI has in fact resulted in a new way of working with the computers, new way of using computers, and then generative AI has become so much of a creative option for creators. So it has brought in a change in the human technological interaction, because here users know one thing, that they are dealing with something that is immensely creative and unprecedented way, and then the powers and then the creative capacity is limited more by what you really want to do from it or what you want to derive from it, rather than the limitation of technology per se. Or the limitation may come more from your own limitation to imagine and then adapt and then use it, rather than from anywhere else. So this is the implications over there. But then there are a whole lot of things that we need to really figure out. For example, what is the implication of the general directive on data privacy? And then what is the implication of the privacy issues over there, and then IP rights? And more importantly, when generative AI use so much of the materials of the human authors, how do we remunerate them? How do we honor them by ensuring that they get decent and then remuneration which is due to them, particularly when the copyrighted works are used by generative AI in an extensive way. So the use of digital use by authors is something which we need to be very, very appreciative and be careful about. But what do they derive in turn if they use digital tools which also use their own materials? So the parameters here is that you contextualize, you iterate, you improvise, and then this is a virtuous circle which goes there. So when these things happen in generative AI models, it is like a learning cycle, that loop that goes on endlessly. So when this happens, the use of materials also get enhanced, also gets more and more, and becomes something like a virtuous cycle, not a vicious cycle. But language here is more an input as well as an output. So Google's Translate feature and virtual assistants use language both as an input and output when they translate or when they transform our queries into different matters. But accuracy of content and moderation process also equally important, because user input data enriches NLP driven tools. So the content moderation, data enrichment often goes parallelly, hand in hand. But the problem comes in a very unanticipated, interesting way. There is a distinction between reading and copying, in the sense that when my eyes look at a text, when I read a book, I'm only reading it, I'm not copying it. But when an AI system uses it, the very act of reading also takes into account copying, or it becomes copying. Because when I read a book, when I see a painting, I am only seeing it. I may be mentally imbibing it, I may be mentally absorbing it, or it could go into my brain as a visual image. But then I am not copying it, in the sense that I am not storing it or I am not using it further in my own brain. But AI systems use it in a specific way. So they, even when they scan, when they read within quotes, they copy. But the problem here is that today AI models are also using a lot of synthetic data. And then the synthetic data are again generated by AI models, AI systems. And then the synthetic data could be based and derived from the available data, which again could be protected by copyright. So this becomes a huge issue because synthetic data is really a new beast which we have to understand and deal with. And then synthetic data, although it could be very much derived from the available data, which it itself would be protected by copyright, but boundaries here, who exactly owns the copyright or who exactly owns the rights or the materials which synthetic data keeps on producing and reproducing and derives. Problem comes in many other ways also. First of all, synthetic data, if we define as artificially generated using real data as input, it has got the same statistical proportion as real data. So is it really an imitation or is it something totally new? That's the first question. Even the synthetic data within course synthetic, is it really synthetic? Then it actually is not the something that needs sufficient quantities of real data, in the sense that it is not something 10% that is synthetic, 90% original. It is not like that. Now, I can create synthetic data of an author by using the author's works. I can imitate the style in synthetic data. I can ensure that the writing style is imitated, the same phrase, the catchphrases, or the phrases for which the author is well known, the writing style, the author, how the author's typical phrases and then writing things are can be part of the synthetic data, but by imitating, by understanding and then imitating, reproducing it in the same way. So, can synthetic data come anywhere near the original work in terms of author's insight and brilliance in thinking? Is a debatable point. For example, if I create a synthetic data out of the work of either Dostoevsky or Shakespeare or Rabindranath Tagore, is that synthetic data, will that come anywhere near the original work in terms of sheer brilliance and then thinking? It may not. But then when I read it, I may be able to see the traces. I may be even be fooled that this is written by the Dostoevsky, although it may lack the originality, it may lack the brilliance in terms of content. And then the real problem comes that synthetic data can be produced right, left, and center in unimaginable quantity. If the author took a decade or months or weeks to write something, my synthetic data can create quantities unimaginably. In the sense that my synthetic data can create 4,000 4,000 page, 5,000 page novels from the works of an author. Although authors' works they themselves put together may not be more than 1,000 pages or 2,000 pages. So the enormous quantity itself creates a huge problem for copyright in terms of copyright holders' rights, in terms of the very idea of copyright being available as a IP right. So author styles may evolve, but then they may retain the individual elements in that. When I use synthetic outputs to train my AI system, they are in one day going to surpass the generated data very soon. So as it happens beyond a level, it is really difficult to differentiate between real data. In one sense, as it is multiplies, synthetic data becomes huge in terms of quantity. The situation is like that. If we conceptualize synthetic data as counterfeit notes, when the circulation of counterfeit notes becomes more than the notes printed or put to circulation by the authorized authority in India, that is Reserve Bank of India, it is really difficult to differentiate between them. So amount of synthetic data being too huge becomes difficult to differentiate from the real data. Coming to the next point, the analytical findings from the synthetic data often give the same insights from the original data. And then synthetic data becomes easy to uptake for computational abilities. Storage possibilities make it all the more easy to store and then analyze. And then it also can result in better, advanced, improved algorithms. There are some synthetic data usages which we can say. Synthetic text in wild for sense text detectors. Dostoevsky's synthetic images of chairs for generative AI models. So synthetic data usage, there are a lot of good examples being available. So the value and transition to synthetic data as it happens also creates huge problems in terms of enforcing copyrights, particularly the rights for right holders. Coming to that, the boundaries between the real and synthetic data as they get more and more blurred. What is true, what is false, what is real, what is imaginary, what is something that floats in between is a problem. And deepfakes often contain substantial synthetic elements derived from the original works, synthetic elements that are built upon the original works, and then to identify and differentiate them becomes a huge issue. Now, to make things more complicated, today it is feasible to create real-time, very high-quality generative AI outputs, whether they are deepfakes or not, it's a different question. For example, live video can be superimposed on a targeted video clip and then can be generated endlessly. And then quick succession of images captured from different sources fed to a single source and then multiplied across becomes a huge problem because they occur in huge succession. And then they result in high quality deepfake videos which look so authentic that it is simply difficult to say that they are deepfake. They are so, easily manipulatable that we tend to consume them, we tend to see them as the original works or the works that are really true. And then ease of creation also means that you can create deep fakes from deep fakes. Again, further circulation of deep fakes becomes easily possible. And then endless cycle of deep fakes creating deep fakes is a nightmare, but then technically it is feasible and it is happening. When synthetic data is used in AI training, it could use datasets, images, audio-visual works. For example, AlphaGo of the Google's DeepMind was used in real-world inputs like game rules and then strategic moves. So it was using them repeatedly to simulate and then to learn and improvise. But it identified a strategic blind spot which was overlooked by humans. And then that made the huge difference that Google DeepMind's AlphaGo, which is again used to play or used to play the game Go, defeated the best AlphaGo player effortlessly. Or when it identified a strategic blind spot, it was the best player. So use of synthetic data can have or can result in unanticipated consequences. But there are legal implications of synthetic data. First, the role of synthetic data in law is very ambiguous. It addresses the limitations of data action analytics because it involves both personal and non-personal information. So where does the personal data end? Where does the non-personal data begins? It becomes a problem. But then data protection and privacy, complying with that is a huge issue. But the synthetic data retains and preserves the statistical properties of the original data. So is it really GDPR compliant? Does it protection over the personal data available? Again, we are not sure. So if synthetic data can facilitate compliance with GDPR, then some issues can be addressed and resolved. But the problem here is that it retains value without identifying the data subjects. So the synthetic data will be still valuable, but then the identifiable data subjects may not be known. This we are talking in the context of GDPR here. So it's also possible to do some anonymization there. So the legal implications of synthetic data are huge, but then which law should be applicable under what context is again a gray area over there. Then the copyright challenges in the European context is that it facilitates compliance with GDPR, it is possible. But then it creates new challenges for copyright and related rights. But on impact of the human authors, it distances the romanticized human author when it comes to the core of copyright. For example, ChatGPT uses large data sets and then high computational power, uses complex words mimicking human-like words. And then where is the human author here? It is being, he or she is being mimicked. So the Authors Guild's lawsuit questioned if LLM's use of copyright protected is systematic theft on a mass scale, which is true. So they said OpenAI allegedly used substantial copyrighted protected content without giving licensing fee. So the copyright concerns are very huge and then they are very significant, particularly when synthetic data is being created without getting any proper licensing. So we need to remunerate the human author. Machine learning does result in large data volumes to discover patterns. It does create new knowledge. It also generates lot of insights. But permission from authors to train LLM models becoming debated. Lawsuits are being filed one after another in different jurisdictions, and then the different jurisdictions almost the same defendants appear, whether it's OpenAI, Stability AI, Meta, and GitHub. And then training and content copyright infringement is a huge issue. How do we remunerate the real human author when so much of data, so much of synthetic data floats around? The question of value chain of general AI, it is again derived by copyright consideration. It includes contents and data sets used for training. So where exactly the author can figure out the value chain and then say, look, my material is there in full form, but here my material is there in synthetic data form. And then the authorship again is a question because we will see later in Stephen Taylor's The Creative Mission and the recent entrance to Paradise, US copyright refused registration due to lack of human author in that because they are AI generated content whose specific authorship the US Copyright Office refused to register. Then one legal district upheld the requirement for human involvement in copyright protection. Then this five test also comes in, so to address the AI-based output with human creative contribution. In future, things are going to be all the more complicated. So access to content and licensing becomes somewhat difficult and somewhat easy if open source content is made available, but the lack of content is become payable paid walls. And then you can use Creative Commons license. Some special licensing may be required for TDM, that is for TDM purposes. And then specific license will be needed for mining, that is text and data mining license purposes. Firms must fairly license authors' works, but then who will do it? And then the European Union's negotiations, which we saw, but then there is no global harmonization when it comes to text and data mining. Extraction and copying of content is again distinct from content availability. Access does not give you the right to engage in text and data mining. In the sense that when I say I give access for you to go through my website, that does not by default extend the license to engage in text and data mining to you. Of course, we discussed there are relevant exemptions available, and then there are relevant exceptions available for scientific and other research purposes. But then, generative AI's influence on creativity is very huge, particularly when generative AI like systems like Bard generate human-like outputs. The quantity is unmatched, but no author can be so prolific. And then they analyze human creativity, human creations through text and data mining. So the need to remunerate authors comes from philosophical foundations of copyright supporting compensating human authors. Generative AI outputs are based on original human works. Copyright is a privilege, but then copyright permits third party to use works, but to what extent? This right paradoxically strengthens bargaining position, but how far authors will be able to bargain is a big question. And then when the cycles and loops of generative AI, when that happens repeatedly, impact on authors' bargaining position is not very clear. Key issue in legal discourse is that relationship between what is comes under TDM and what is access to the content. Cases in USA highlight the infringement by ChatGPT. Again, EU's license-driven approach gives lawful content access as a prerequisite for TDM exception. But then there are additional transaction costs for the high-tech industry when they want to engage in text and data mining in it. Alternative remedy which we saw is levy, again problematic. How to ensure equitable remuneration is again a big issue. Again we said the levy, general levy is supported by some authors, but then distinction between inputs and outputs is not very clear in this. So the objective of copyright potential AI to create new creations to emanate from older ones in multiple ways through multiple means. Enhancing creativity is feasible by creating new generations to use pre-existing works. And then the role of exemptions and limitation is to balance, but then how to do that? If Canadian Supreme Court in 2004 recognized this as a user right, European Court of Justice echoed similar view in 2019. But to design a broader exception and licensing work, should that be confined only for text and data mining, or should that be extended to another use, particularly in the context of AI? It's a big question. So in the next class, what we will do is that we will look at generative AI IP training data, and then we will make some final observations in the context of copyright and AI.